welcome to BBA News Report. I'm Yvonne. The first piece of news is a court case between Hedley and Heller concerning a negligent misstatement. Hedley were advertising agents. One of his clients was Easy Power. Hedley was considering extending a credit to Easy Power and thus asked Heller for a reference for Easy Power's financial situation. Let's see what happened next.
This is the relationship chart of the parties. Hedley is the plaintiff as the advertising agent, while Heller is the defendant. Easy Power is Heller's client, and it is doing a business with Hedley. Heller's bank, I was considering doing a business with Easy Power. I'd like to know whether Easy Power is creditworthy.
I have reviewed its financial statements. I think it is considered good. You should have no problems with it. Heller's statement was made without responsibility on its part. Relying on the reply, Hedley made an advertising contract with Easy Power. After a month, Easy Power went into liquidation.
Now Easy Power has gone into liquidation, and I relied on your information and lost £17,000 on the advertising agents. What's going on?
I'm sorry, dear. I don't think I'm responsible for that because I've issued a disclaimer along with my report. I shall not be liable for your loss.
The issue now is that whether Heller is liable for the loss suffered by Hedley. Does a sufficient proximate relationship exist between Hedley and Heller? Does Heller owe a duty of care to Hedley? The final thing is the disclaimer legally binding?
A sufficiently proximate relationship exists between Hedley and Heller. Hedley relies on the information given by Heller regarding Easy Power's financial situation to make a decision. A special relationship exists. Heller would have to take sufficient care in giving advice to avoid negligence liability.
The disclaimer is legally binding because it protects Heller from being liable for negligent misrepresentation, provided that Heller is truly faithful without fraudulent motive.
Auditors have certain responsibilities in issuing audit reports. They have to exercise professional due care to issue a fairly stated financial statements. To avoid misleading users of financial statements who will rely on them to make investments, auditors should collect sufficient evidence. If not, a disclaimer should be issued to protect the interest of them and the users.
What if there is no disclaimer between the two parties? Since Heller owed a duty of care to Hedley, Heller is liable for his negligent misrepresentation. There will be a remedy of pure economic loss of £17,000.
The court held that the defendant was not liable for his negligent misstatement and that the plaintiff could not recover any losses. For further updates, stay tuned. Thank you for watching BBA News. I'm Yvonne.